All right, and we are back with our second section of Jefferson. In this one, we're going to look at Marbury versus Madison. We're going to skip down on your slides to slide 14. I know you guys have a couple of critical thinking questions in your PowerPoint. You don't have to worry about those. It's just kind of helped us set it up if we were having a class discussion. Feel free to ask me about it in our Q&A, but let's get started about Marbury versus Madison. So, one of the things presidents try to do at the end of their administration, after the election has happened, and if they know they're not going to be president, is they try to make appointments. And I don't mean like, hey, here's my date book, let me mark this off in my calendar. Appointments, as in choosing people to specific positions. The reason that they try to do this is so that they can get their people in office before it changes to another president. The big one here that Adams tries to do at the end of his presidency is going to be electing federal judges. So, background on federal judges, one of the things we've talked about is they are a powerful position because you cannot fire a federal judge unless there is a problem in the courts or unless they've been convicted of doing something wrong. If you are chosen to be a federal judge, you have that appointment for life. That's part of our checks and balances. That is where Congress has to approve the president's position. So it's a very powerful position or appointment to have. John Adams is worried about his political party. So remember, Washington was a Federalist, Adams was a Federalist. Now we have our first Republican that is going to be in office with Jefferson. So John Adams, at the end of his presidency, is going to do a couple of things to try and protect the Federalist Party. The first thing he's going to do is make a huge number of appointments of Federalist justices to federal courts. So making sure that he picks people who are the same mindset or political party that he is. He's going to choose them because he knows they can't be fired. He's also going to increase the number of judges he's allowed to have. It's called the Judicial Act of 1801. So he's going to pass this through Congress where he can get more judges allotted in the system. We call these judges the midnight judges because it's like Cinderella, where at the stroke of midnight, his term is ended. So he's trying to get them in before the clock strikes midnight. As it says down there, what is Adams' goal in choosing Federalist judges? He wants to pack the courts with Federalists. So he wants his party to be protected. Congress at this point is shifted from Federalist majority to Democratic Republican majority. The president is now a Democratic Republican. So the last branch of the federal government that we have is the judicial branch. So we want to make sure that those justices stay in the Federalist Party. However, there is a problem that we're presented with. The paperwork where all of these appointments were made is signed, sealed, and delivered. All of it's checked off, all the I's are dotted, T's are crossed. However, it is not delivered in time. So it doesn't make it to the desk of the person who it needs to make it to in time before Jefferson actually gets to be president. So the question that we have is, should these appointments be accepted? The way I want you to think about this is, say that you went through the hiring process to work at McDonald's, Bojangles, Walmart, what have you. You fill out all the paperwork, you get the interview, you are told by word of mouth that you got the job, all of your paperwork is complete, you sign everything, but then somehow your paperwork gets lost in the mail and doesn't make it to the right person and someone else gets your job. Would you be angry about this situation? Of course you would be. You went through all that work, you were told you had a job, you don't think it's fair. So what we would normally do is we'd read about Marbury versus Madison, but we're going to skip forward and talk about the players in the situation here. So the guy who is going to be angry about not getting his appointment is going to be this person right here, Marbury, William Marbury. William Marbury is one of those Federalist judges that was promised a job by Adams. It was supposed to be delivered to the Secretary of State, which is James Madison, and James Madison does not accept the appointments. So we're going to have an issue between Marbury and Madison. The president, who was listening to the situation and trying to figure out what the best scenario is going to be Thomas Jefferson. And then we need to talk a little bit about who is the Chief Justice. John Marshall was chosen as Chief Justice when George Washington was president. Chief Justice Marshall is going to serve for over 30 years on the court. And he is a Federalist, so he's going to have the Federalist mindset. These two guys, Jefferson and Madison, are both Republicans. Marbury is a Federalist. So again, we're seeing these party politics pop up, and we're trying to figure out how we're going to handle it. There's a reason Washington said no parties. You can see it's kind of following us through this whole situation. So let's talk about who is actually upset at being denied. William Marbury was told by Adams that he would get the commission, he would get the job as a Federalist judge. What he is going to demand is to have a writ of mandamus. Define writ of mandamus, what role does it play? A writ of mandamus is a fancy way for saying you're ordering somebody to fulfill their job requirement. So say that you had a job of sweeping and somebody saw that you were not actually sweeping when you were supposed to, they could order a writ of mandamus that would basically make your supervisor force you to sweep. So it's forcing you to do what your job is actually supposed to be. So the reason they bring that up in court is because William Marbury is trying to make James Madison give him the job. So the job of Secretary of State, which is what Madison is supposed to deliver appointments, give people their jobs. Madison is choosing not to give him his job. So Marbury says, you have to give me my job. And he takes it to the Supreme Court. That's why it is a Supreme Court case. All right. What is Marbury's argument to the Supreme Court? The reason he's mad is because he was entitled to the writ and the job, his commission, because it had already been created. He had filled out all the correct paperwork. The Supreme Court had approved it. But again, Madison was not doing his job as Secretary of State, and therefore the Supreme Court had the power to tell Madison what to do. They also had the agreement that it had to be done because of the Judiciary Act of 1789, which was written under Washington. That act had established the Supreme Court and told the Supreme Court what kind of cases it could hear. So this is kind of a twofold question. Marbury wants his job. Madison is supposed to give it to him. It has to be heard by the Supreme Court because of the Judiciary Act. That's a little bit more intense of an explanation than what you'll be asked about, but that does kind of help you understand all the different moving parts. All right, here's the decision. And this decision is extremely important because we're going to give the Supreme Court a power that it's been lacking. Why did the Supreme Court not give Marbury his commission, even though they agreed he had a right to receive it? So one of the big things here is that the Supreme Court argued, and John Marshall, the Chief Justice on the Supreme Court, argued that, yeah, William Marbury should be getting his job. Yes, they filled out all the paperwork, all of the correct steps were taken. However, there is a bigger battle at hand. And the bigger battle at hand is that the Judiciary Act that listed the Supreme Court powers and gave powers to the Supreme Court was not actually constitutional. Congress had created the Judiciary Act, and that's not a power that Congress has. The only power that Congress has when talking about courts is going to be to create lower courts. But any kind of power given to the Supreme Court from Congress is not constitutional. The Supreme Court can only get its power from the Constitution. Therefore, that act is unconstitutional. And because that act is unconstitutional, it is also unconstitutional for Marbury to try and sue Madison in the Supreme Court. So we are taking it to the extreme. You've got Chief Justice Marshall saying, hey, Marbury, we're really sorry, but we've got a bigger picture problem here. So let's talk about why that is significant. The fact that the Supreme Court is able to say that a congressional law is unconstitutional is an example of judicial review. And judicial review is the biggest power that the Supreme Court has. The ability to say a law is unconstitutional has finally given the Supreme Court the ability to balance out itself. If you think about it, in the beginning, the president and Congress had most of the power. The Supreme Court didn't really do anything. But now that we've given them the power to review congressional law and declare if something is unconstitutional or not, we've officially balanced out the three powers. So effectively, what we've done is strengthen the Supreme Court, and that is a huge deal. If you are still confused about Marbury versus Madison, because if you look at it, it seems like a huge cluster of information. The book has a really good summary on page 226 and 227. If you are still confused, that breaks down all of the legal jargon and the background and why things happened the way that they did. Again, if you have questions, feel free to write them down, and I'll try and answer them in our next Q&A. We're going to take a quick break, and then we'll be back with more on Thomas Jefferson.